In this video, I'll show you June 24th, 2019. Protester Victor Scott was holding a sign outside of an Ace hardware store owned by Charles Grigg in Pasco, Washington, when he was approached by Officer Eric Fox of the Pasco Police Department, who was there to serve Mr. Scott with a restraining order issued after a previous altercation with Mr. Grigg. Although the specific details about the dispute are unclear, both Mr. Grigg and Mr. Scott contend that the other assaulted them. The body cam footage begins with Officer Fox approaching Mr. Scott outside the store and announcing himself.
Fox!
What do you want? Are we gonna do this again, Bob?
What's that, buddy?
Are we gonna do this again or what?
I just need to chat with you for a moment, man.
Tell me, bro. That doesn't go very well. You guys like to insult people.
Well, Victor, we've had two good talks in the last couple of weeks.
Yeah, we have a good talk, but I also find out you're working with a department that has decided that they want to try and do. And I'm not taking anything from your hands, sir. I know that. And you can go ahead and walk with me. Don't.
Oh, I will. I'm going to walk with you.
That's civil service. That's fine. That's fine, but I'm not going to take it from your hands.
So what this is, it's a restraining order.
It's a restraining order for what?
Protecting Charlie Grigg from you.
He assaulted me, and
Okay.
you guys are. So no, is your thing on right there?
Yeah, we're being recorded.
So he assaulted me,
Okay.
and now you guys are protecting him. You guys are making my freedom of speech under duress, and you guys are literally on my civil rights. He came out and assaulted me with witnesses. My children were here and witnessed it, and you guys choose to put a restraining order on me.
So I wasn't there for that.
Is that? I mean, no, I know you weren't. And
Okay.
I'm sure you weren't. But the funny thing is you guys want to put a restraining order on me.
I don't want to restrain anybody from
absolutely.
anything.
No, absolutely.
This is from Superior Court. This isn't from me.
I have no clue where that's from, and I haven't looked at the document yet, and I don't mean that rudely, and I'm not trying to be a...
Oh, you're not being a... You're fine.
I appreciate being a little more of a man than Jason Miller.
Yeah, I saw you don't like him.
So I don't like him.
Yeah.
So we can come back this way right
Okay.
now for a little bit. I have my stuff over this way.
Okay. Yeah, let's not get too far away from your stuff.
Absolutely. I'm just so you guys know, you're also being recorded on 3 different devices. Audio also, not just video.
Okay.
You're being
Same
videoed in my
here.
right pocket, and my left pocket
Okay.
is audio.
Okay. So what this is, it's a form. You need to read it. There's very important information.
What does that form say? It says
Okay.
basically...
I'm gonna put it here. I'm gonna let you read
That's not in my
it.
possession.
Okay.
I can grab it, sir. Sir,
Well,
that's not a service, sir. You know that's not a
It
service.
is legal service now because I
How is
can't
it
give it to
service?
you.
I can't grab that. I have a backup. If you pick that up for me, maybe, and you could discuss, maybe, hey, sir, will you take this from me? Maybe then we could have some dignity.
Okay. If I ask you, will you take it? Will you?
It, Batman.
Will you?
See?
Okay.
Will you treat me with dignity?
So.
Will you
Here.
treat me with dignity?
I will gladly treat you with
And
dignity.
you're not going to trespass me. Once you hand that to me, you're going to allow me to get away from here, right?
Will you take? No, I'm not going to trespass you. I'm not going to arrest you.
I'm just asking.
So, like I
know
said
how
at the
the
courthouse,
system works.
we don't want to arrest you. I don't want to arrest you. That's why I want to advise you and inform you.
But this is slander.
So-
And you guys are participating in slander.
I'm giving a
I know
piece of
that- I
paper
know
by the
that.
court. I'm not
But
slandering you.
Mr. Scott accuses the Pasco PD of participating in, quote, UN, quote, slander by serving him the restraining order, although the basis for this assertion is unclear. Like libel, slander is a type of civil action that an individual can file against another for making false statements that harm their reputation, also known as defamation. Although the distinction between libel and slander is not entirely clear-cut, slander generally refers to oral defamation, while libel refers to written defamation. The specific requirements to make a defamation case may vary between states, but the Supreme Court of Washington held in the 1981 case of Mark v. Seattle Times that, quote, a defamation plaintiff must show 4 essential elements: falsity, an unprivileged communication, fault, and damages. While this does not appear to be an instance of defamation on the part of the Pasco PD, the sign Mr. Scott was holding, which asserts that Pasco police officer Jason Miller, quote, beats the disabled, could potentially be considered defamation. Unsurprisingly, the courts have frequently been asked to draw legal boundaries based on the elements of defamation claims and the First Amendment right to freedom of speech, and in the 1964 landmark case of New York Times v. Sullivan, York Times, Covey Sullivan, the Supreme Court did just that, holding that the constitutional guarantees require a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct, unless he proves that the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. In reaching this decision, the court reasoned that the level of fault required for someone to commit defamation, a public official should be higher than the standard for defamation claims against ordinary citizens in order to prevent public officials from using defamation lawsuits to silence their legitimate critics. In the wake of this decision, the Supreme Court of Washington held in the 1969 case of Tilton v. Coles Publishing Co. quote, while under certain circumstances, police and firemen may be considered public officials within the New York Times rule. To come within the privilege, a public official must have been defamed in respect to his official conduct. Given the strict standards for a public official to prove that, an individual has defamed them. As long as Mr. Scott had some basis for his accusation against Officer Miller and the conduct occurred in the course of his official duties, a court would likely determine that Mr. Scott's sign did not constitute actionable defamation against Officer Miller.
Paper with his side. I didn't hear about this until you told me.
No one has, and that's just it. And then, see that camera right down there real quick? I want you to just be honest with me. You can see it down there, right?
Yeah.
That white ball camera?
The one up
on the very corner, right? On the very far corner of the building. And there's also one underneath the eave.
I got you, yeah.
There's also one right on top, see, pointing right on the very top, right there.
I got you, yeah.
He tells you, Officer Spitzer, he's got no cameras because he physically assaulted me.
Okay.
I'm going to show, I'm not going to, thank you, sir.
Thank you.
I haven't read it yet, so you can't ask me to leave, but you have to give me a decent amount of...
The officer serves Mr. Scott a temporary anti-harassment protection order that Mr. Grigg has obtained against him in the District Court of Washington for Franklin County, which includes notice of a scheduled hearing regarding the protection order. A protection order is a type of restraining order that is used by a court to protect an individual against domestic violence, assault, harassment, or stalking. In this situation, Mr. Scott has been issued a temporary anti-harassment order under Section 10.14.080 of the Revised Code of Washington, which allows one individual referred to as the petition to receive an ex parte temporary anti-harassment protection order against another individual, referred to as the respondent, by filing an affidavit that shows reasonable proof of unlawful harassment and that great or irreparable harm will result if a temporary anti-harassment protection order is not granted. Section 10.14.020 of the Revised Code of Washington defines unlawful harassment as, quote, a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person and which serves no legitimate or lawful purpose. Under this statute, an individual can receive an anti-harassment protection order against another for up to 14 days without notice being provided to the petitioner and without the petitioner having an opportunity to defend themselves. If a temporary anti-harassment protection order is granted, a copy of the order and a notice of hearing must be personally served to the respondent. The court will then hold a hearing within the 14-day time frame that the temporary protection order is in effect, and if the court finds that unlawful harassment exists. A civil anti-harassment protection order prohibiting unlawful harassment for up to 1 year will be issued. If the court finds that unlawful harassment is likely to resume when the order expires, the court can issue a longer protection order, or even a permanent anti-harassment protection order. Because this is a civil protection order, the standard of proof is different from a criminal trial, where the prosecution must prove beyond a reasonable doubt that an individual committed a crime. In this case, the petitioner only needs to prove that unlawful harassment exists by a preponderance of evidence, which means that the court must decide that it is more likely than not, or more than 50% likely that the harassment is occurring. If the court grants any type of anti-harassment order, it can prohibit the respondent from making any attempts to contact the petitioner or keep the petitioner under surveillance and require the respondent to stay a stated distance from the petitioner's residence and workplace. In this case, the temporary protection order Mr. Gregg has received against Mr. Scott requires him to be 1,000 feet from Mr. Gregg, his residence, and his place of employment. So, upon receiving the protection order, Mr. Scott became legally obligated to leave the store parking lot after he came.
To me repeatedly 3 times closer than we are at this current moment.
Yeah.
With his fist back and his teeth glared at me like he was pissed. I could tell you his dental hygiene. I can tell you he's got some plaque around his teeth and his gums are receding.
Yeah.
I can literally tell you that as a testifying court, and that's fine. But what I'm saying is, after 3 times repeatedly coming in on me, he physically knocked my sign down and swung his shoulder across and blew me backwards right in next to that light pole right there. I was just on the back side of it, and knocked me backwards, and then said that I was assaulted. So he said, "Oh, you just assaulted me." And I said, "If you don't stay back from me, I will defend myself." I did say that. Okay. That's not a threat. That's called an if-then statement. If this, then that, because of that.
Mr. Gregg, he claims that he did not make any threats, but rather that he used an if-then statement to inform Mr. Gregg that he would defend himself if Mr. Gregg did not keep his distance. Under U.S. constitutional law, statements to others that are considered, quote, UN, quote, true threats are not protected by the First Amendment. In the 2003 case of Virginia v. Black, the U.S. Supreme Court held that, quote, the First Amendment permits a state to ban true threats which encompasses those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. In line with this grant of authority, Section 9, A.46.020 of the Revised Code of Washington states the quote, "A person is guilty of harassment if, without lawful authority, the person knowingly threatens to cause bodily injury immediately or in the future to the person threatened or to any other person." Although this statute criminalizes making threats of bodily injury, it only prohibits making such a statement when an individual does not have the lawful authority to do so. In the 1988 case of State v. Smith, the Supreme Court of Washington determined that, quote, threats of bodily injury lawfully may be made when circumstances justify violent action in self-defense. The use of force against another, including causing injury, is privileged when necessary to protect persons or property. An individual who is privileged to cause injury undeniably is privileged to threaten to do so under Section 9, A.16020 of the Revised Code of Washington. The use attempt or offer to use force against another is legally authorized, quote, whenever used by a party about to be injured or by another lawfully aiding him or her in preventing or attempting to prevent an offense against his or her person, or a malicious trespass or other malicious interference with real or personal property lawfully in his or her possession, in case the force is not more than is necessary. Therefore, a court would most likely find that Mr. Scott's statement that he would defend himself was not a threat for the purposes of the Washington harassment law. However, it's important to note that Mr. Scott's contention that all if-then statements are protected as a human right is not an accurate statement of Washington's law. In the 2010 case of State v. Cross, Division II of the Court of Appeals of Washington upheld a conviction under the harassment statute against an individual who told the police officer who was arresting him that he would cause him bodily injury, quote, if he wasn't in handcuffs. Referring to the statement as a, quote, UN, quote, conditional threat, the court held that, quote, neither the criminal statute nor applicable statutory definition requires that a threat to harm a person must be unconditional to support harassment conviction. Under this standard,
I also need to encourage you to read that, because it does say that you have to stay 1,000 feet away from Charlie Gregg, his residence, and his place of employment.
Okay, so now that's a pretty ballsy statement on the fact. Yeah, I would like that. So I'm here, Officer Spitzer. My freedom of speech is being hindered because I'm assaulted while speaking freely. A man that makes millions of dollars off the Second Amendment can't handle some freedom of speech and literally physically assaults me, and now I'm the one served. Now the lack of the service that I'm getting from your department is exactly what I've been talking about from the beginning, Gregory. 3 years ago with Jones. The lack of service, the lack of dignity. This man, because he owns a business and makes you guys money as taxes, you're more willing to help him than me, the citizen who was assaulted by him. Using my First Amendment rights, which it says you swear an oath to uphold.
I don't know anything about an assault.
Officer Spitzer, read his report. I sent him a little email, and I'll forward.
Threw it on to you, too. You know, I like them email. After a brief and relatively cordial conversation with Mr. Scott, the officers offered him a ride. He accepted, and everyone left the scene without further incidents. As you have probably gathered, this is not Mr. Scott's first encounter with the Pasco Police Department, and the Real World Police channel has posted multiple other videos featuring his encounters with law enforcement. Those interactions were not as peaceful and certainly add context to the behavior of Mr. Scott and the officers. Overall, the Pasco police officers get an A+ for actively working to de-escalate the encounter whenever possible, maintaining a calm and collected demeanor, and remaining within the bounds of their authority throughout the interaction. De-escalation played a major role in the outcome of this encounter, and the Pasco officers maintained an excellent balance between allowing Mr. Scott to voice his opinion and politely interjecting to drive the focus to the task at hand. It is impossible to speculate on the legitimacy of the restraining order itself, but the way the officers went about serving that order was commendable. All of the officers were polite, responsive, and courteous, and they accomplished the mission of their contact with Mr. Scott as effectively as possible. The officers also exercised their community caretaking function by offering Mr. Scott a ride and simultaneously ensured that he was not on the property after being served. This interaction highlights the dramatic impact that an officer being patient and friendly can have on the outcome of any interaction, and I commend the Pasco officers for handling this encounter with care and professionalism. Mr. Scott gets an A- because although his actions could be interpreted as inflammatory by design, he remained within the bounds of his civil liberties, engaged with the officers in a relatively productive dialogue, and ultimately complied with the requests of the officers and accepted their aid. While there are likely more productive channels to redress Mr. Scott's grievances with the Pasco PD and Mr. Griggs, Mr. Scott was not trespassing at any point, and his protest would likely be considered protected by the First Amendment, regardless of how offensive it was to Mr. Griggs. Until Mr. Scott was served with the restraining order, he was well within his rights to stand on the sidewalk next to Mr. Griggs' store, and once he was served with the notice, he peacefully complied with leaving the premises. It is clear that Mr. Scott has had a rocky past with the Pasco PD, and although he voiced an overall negative opinion of the department, he did not take his frustrations out on these officers in particular. The officers took their time to explain why they were there, and Mr. Scott was willing to listen so long as he could be heard in exchange. Mr. Scott's willingness to accept a ride from the officers demonstrates that he trusts these officers to some degree, and the behavior displayed by the officers in this interaction will likely contribute to more positive encounters with Mr. Thank You. Very much for watching the video. Subscribe our channel for next video.